Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, podcast from the American Bar Association Antitrust Law section. My name is Anora Wang. Today's topic is, have states found the answer to subscription traps, click to cancel, and beyond? Joining me today is my co-host, Anna Olson. Hi, Anna.
Hi, Anora.
Would you please do the honor to introduce our guest today?
Absolutely. Our guest, Erin Witte, is Senior Counsel to the New Jersey Attorney General and a longtime consumer protection advocate. Erin previously led consumer protection policy at the Consumer Federation of America, where she spearheaded efforts to combat subscription traps and deceptive business practices. Before her policy work, she served as an assistant attorney general in Virginia, litigating consumer protection cases in state and federal court. Erin, thank you for joining us today.
Thank you for having me. I'm excited to be here.
So without further ado, Erin, I'm going to just kick off the program with Anna asking the first question.
Click to cancel has become a widely recognized phrase. What frustrates people about subscriptions and automatic renewals?
I think what frustrates people the most is when you cannot, in fact, click to cancel a subscription. The Federal Trade Commission has worked on this issue for a long time. The click to cancel phrase is really associated with the Federal Trade Commission's rulemaking that they started a few years ago, but this is actually an amendment to a long-standing rule called the negative option rule. So this subscription trap, problematic auto renewals, this has really been around for a long time, but with the advent of tech that can really make cancellation much more difficult and complex. As we have seen the subscription economy grow, I think some estimates say that it has even quadrupled in the last decade. We've seen this become a really growing problem that is just hard to cancel a subscription. People find that frustrating. It's your money. It's a product that you signed up for that you might want. But then at some point, you might not want it anymore. And you might not want to spend your money on that. And when there's an interference, when there's too much friction in your decision making and your freedom to say, I don't want this anymore and I don't want to pay for it, that's very frustrating and it's annoying. And oftentimes it's illegal. What we've seen is that companies employ these tricks and these traps that keep you in that subscription so that they can continue to take your money even when you have chosen not to pay for it anymore. So click to cancel is this phrase that resonates not only because it's catchy and it's alliterative, which is great comms work, frankly, but it's so resonant with people because I think that almost everyone you talk to can relate to this experience of having a subscription that they could not click to cancel.
Yeah, as a consumer, I feel the pain sometimes. And I think you have said, in some more public saying that it's almost like some business are effectively now competing on who can design the best and most effective subscription trap rather than actual on their product quality, right? So how do concepts like subscription trap and dark patterns intersect with click to cancel legislation?
So it's interesting because we use these words trap and dark patterns. They feel a bit nebulous, right? Like I've heard some defense attorneys complain about the use of the phrase dark patterns because they don't know what it means, but we know exactly what it means. We know what it means when you feel tricked or manipulated into signing up for something that you didn't want or didn't realize was a subscription to begin with, or that you couldn't exercise your own autonomy and control to cancel. So when we've seen state legislators design and adopt legislation, what I think they're really trying to get at is inserting this like informed consumer choice back into the product to give people the power back so that they don't have to be subject to the whims of like chatbots and retention agents and like hidden links and boxes that you can't see or like a 27-page click-through process. That really seems to me to be the thrust of the legislation, is to get us out of this like feeling like you're trapped and you're powerless and that it really is your choice. It's your money and you should choose where to spend it. And so when we've talked about this this weird competition incentive that I think really has arisen with subscription traps. What is interesting is the impact that I think this has not only on consumers, but on honest businesses that don't do this, right? There are lots of honest businesses that have subscription products. You sign up for it, you want to stay in it or you don't, but they don't feel the need to use a deceptive design pattern to trap you and manipulate you into staying, or just hope that you get worn out through this like chatbot process or something. And that really puts those companies at a disadvantage because they don't want to make it hard. They want to make it easy. They want you to want their product. So the underlying product should be better. And really that's how our economy is supposed to work. You should be able to compete on price. You should be able to compete fairly. You should be able to compete on having a better product. But when you have companies that are injecting all of these manipulative tactics to really steal competition and keep people in their product and inhibit them from making other choices or choosing a competitor, I think that has a real disadvantage on honest businesses too. And we've seen honest businesses stand up and support, I know we haven't really gotten there yet, but with the Federal Trade Commission's rulemaking, we saw honest businesses that don't do this stand up and support the FTC's rule for exactly this reason. They didn't want to lose out to dishonest companies that might be bigger, that might have better tech, that might have more money, and just have, frankly, a more effective trap that keeps them in that product instead of letting someone out when they want to get out.
And to circle back to that FTC rule, the FTC's click to cancel rule generated significant attention, but ultimately faced legal challenges. So can you go into that a little bit more in detail and also describe how states have reacted?
Yes, the Federal Trade Commission's rulemaking is something I followed pretty closely when I was at Consumer Federation of America. I was a policy advocate. A lot of what I did was following federal rulemaking and states legislation as well. But during that time, like I said, the Federal Trade Commission proposed this click to cancel rule, but it was really an update to a longstanding rule called the negative option rule. But this was the most poignant part, right? The click to cancel provision would have made it as easy to cancel your subscription as it was to sign up. Frankly, I think that's brilliant. It injects all kinds of proper incentives into the structure, right? If it can be easy to sign up, it can be just as easy to cancel. We know that companies know how to do that. And when they choose to do differently, that's when it becomes a problem and could violate the rule. The rule generated a lot of attention. We saw a significant public comment process. The FTC had to go through a couple steps of public comment. And they did that. They held hearings. They did all sorts of things to engage the public and see how people felt as required by FTC rules and regulations. But what we saw was a lot of consumers weighed in about their frustrations, about what they liked about the rule, what they didn't. But we saw a lot of industry opposition to the rule. Companies and industries that just did not think that this was the best fit. They didn't think that they could comply with it. It would be very expensive for them to change the way that they had designed their processes and their subscription processes, I guess. And so they very heavily opposed the rule throughout the public comment process, throughout the hearings. And then eventually they ended up suing the FTC to undo the rule. And that litigation occurred in the Eighth Circuit. And it was during a time of transition in the presidential administration. The Trump-Vance FTC did defend the rule in the Eighth Circuit, but unfortunately the court vacated the rule in its entirety based on some procedural grounds. So even before that happened in the Eighth Circuit, we saw a lot of states sort of picking up what was happening here because this is such a compelling issue. And we saw states start to adopt their own legislation and start to adopt their own regulations. When I was at CFA, we spent a lot of time helping states craft legislation to start thinking about language that could mirror some of the best parts of the FTC rule, how they could incorporate that into their own state consumer protection statutes, whether it could be a standalone statute. And so we developed kind of like a model framework for states who wanted to think about this. But I think that this was happening before, during, and certainly after the FTC's rulemaking. It unfortunately failed in the Eighth Circuit. The FTC did publish an advance notice of proposed rulemaking to restart this rulemaking process. Unclear what's happening with that. I certainly haven't followed it quite as closely now that I'm at the AG's office in New Jersey, but it is something that they clearly have showed some interest in. And I think the Federal Trade Commission is still bringing enforcement cases against companies that are violating other rules that regulate subscription practices. So there are a couple rules the FTC and states can enforce, but this click to cancel provision, this making it as easy to cancel as it was to sign up, was a really key part of that rulemaking. And I think that is something that we've seen replicated in states all over the country.
Yeah, thanks, Erin. So much attention has been drawn to the rulemaking and then the legal challenges at the federal level. And I think you already mentioned states are already taking actions, but take it apart just a little bit. How are states in terms of their legislature? How are they well positioned or not to address these issues? Would you go into a little bit more depth in terms of the state legislatures and like what kind of resources or leverages they would have?
Yeah, absolutely. I think, again, because this is such an issue that everyone can understand, it's not like a complicated tax problem. It's not some utility issue, right? Like it's not something that is niche or kind of ununderstandable. It's very practical and it has very real implications right away. So I think it is a compelling issue for state legislators to take up because everybody gets it. And so for that reason, I think it is also not a partisan issue. That's something that as a policy advocate, I did think about quite a bit was where would this work? Where wouldn't it? Where do we have relationships? Where don't we? How can we work with allies that we don't normally work with? And I think this was a great issue for that. We really sort of expanded our touch points. We were able to work with all different kinds of legislators in all different kinds of states and help them think about this problem that affects everybody. Subscription traps don't care what political party you are, right? Like they don't necessarily discriminate in that way. And so I think this problem affects everyone, and states have been well positioned to adopt their own legislation. So when I was at Consumer Federation of America and we were looking at states that might be good places to introduce legislation, or we got outreach from a particular legislator, what we saw was that a lot of states, kind of like the FTC, many states had existing auto renewal statutes on the books already. I had practiced in Virginia for quite some time. And so Virginia had a statute that was on the books already for auto renewals, but it was kind of out of date. There were some weaknesses that could be fixed. And we saw that a lot of states were similarly situated. So the strategy kind of depended on what the state had, and states, pardon the pun, but they're all over the map on what kind of legislation they had in place, what might be a good fit, what existing consumer protection statutes they had, and whether like a click to cancel bill would fit into that rubric or whether it needed to be something similar. So I think states have been very well situated to pick up, I guess, the slack here because we don't have a federal rule, and to sort of take this on and really start pushing forward. But it does sort of lead to this dreaded, quote unquote, patchwork of different provisions in different states. The real benefit of the FTC rule would have been that it was a very clear line, industry-wide, and everyone had to play by the same rules. There were some drawbacks to the FTC rule, though, right? The Federal Trade Commission rule would not have been privately enforceable. So it also wouldn't necessarily have been enforceable by state attorneys general. So it was a rule, trade regulation rule, that told everybody how to conduct their affairs that the FTC could enforce. State attorneys general didn't necessarily have that authority through the FTC rule to enforce it. And an individual consumer, if they were harmed, would not be able to bring their own lawsuit based on the FTC rule. So a real advantage that states have is when they were adopting legislation, or when they're considering adopting legislation, is to make it privately enforceable by individuals. I was an attorney in Virginia. My first job out of law school was working for a law firm where I represented individuals. I was in private practice. I did consumer protection on the plaintiff's side. And so this experience of having like a consumer protection statute that allowed me to represent individuals instead of hoping that the attorney general would open a case, hoping that it would go well, hoping that my clients or the affected population would get relief from that enforcement action. At the time, my job was to do the best job for my clients. So I was very grateful that we had a good consumer protection statute that allowed for private enforcement. Not every state does. So again, this is just like another way that it can be very different depending on the state versus the federal government, whether it's a trade regulation rule, whether it's a statutory provision. So there's all kinds of different ways that you can approach this. And I think states have been very willing to be creative, to include strong terms and ensure that really what they're doing is telling industry that we're tired and we're fed up of subscription traps and we want you to kind of get your act together. And I think we're starting to see some change in that regard, which is really encouraging.
Have you noticed at all if momentum has picked up since the rule had been vacated? Does it seem to be stagnant? Have you noticed any sort of trends, especially since we see that the NYC rule is being promoted on social media and getting young people excited about it? So what are your thoughts on that?
Yes, New York City's rulemaking was very exciting to see. I think this is an administration that is very clued into what real people are experiencing, and the rulemaking was very creative. And of course, Sam Levine was the Federal Trade Commission's the director of the Bureau of Consumer Protection, and he's now the commissioner of their Department of Consumer and Worker Protection. So was really glad to see him promote that rulemaking. But Massachusetts also did a rulemaking, right? Like we've seen other states sort of flex their regulatory powers to address this as well. And to answer your question about whether it's become stagnant or whether it's moving, I think that I'm a bit biased on this issue because I think states are incredibly active on consumer protection. I think states very much recognize right now that there are some pretty significant gaps that need to be filled. On subscription traps in particular, like I said, the FTC has been bringing enforcement actions, which is phenomenal. I'm very grateful to see that those consumers who have been harmed will hopefully be getting the relief that they deserve, and that these law enforcement cases are sending the message to industry to clean up their act, that we're not tolerating subscription traps anymore. But having states that are willing to do this on their own, that are crafting legislation that could give someone their own private right of action, it could enhance penalties, right? Like they can do a lot in a state that might not necessarily be as capable at the federal level. And again, I think states are just very interested in this, and states are picking up the mantle on a lot of consumer protection issues right now, and subscription traps are no exception to that.
And you mentioned earlier that the potential consequence of having different states pass different legislation is a patchwork of different sort of frameworks for any sort of resolution to those issues. Is there a significant difference among how states are approaching this regarding what qualifies as the same medium, whether companies may use save offers or retention flows during the cancellation process? What sort of remedies are available?
Yeah, there's a couple of key components to a click to cancel bill or an auto renewal statute. I think, like I said, the overall thrust of this really should be to prioritize informed consumer choice about the process. That is upfront when the company is advertising their product, the price that they're advertising, the terms that they're advertising, what are you getting, and is it a subscription? I have many friends and family members, and I'm sure you all do too. I'm sure that this has happened to me at some point as well personally, that I signed up for a subscription and I didn't even realize that it was a subscription. So even that informed consumer choice at the outset is a really important piece. And there are things that you can do to effectuate that we've seen state legislatures try to put into their legislation. So another key piece of this is, like I said, the click to cancel part itself, which ensures that the cancellation mechanism is as simple as the sign up mechanism, injecting this very straightforward incentive process into it to ensure that the company can do it. We know that they're capable of it. If they're using the same technology to design it, it should be very easy to implement. We also have seen states that want to consider inserting reminders, right? Like requiring the company to send you a 30-day or a 60-day reminder about the fact that, hey, you have a payment coming up, right? And maybe that reminder includes some information about the cancellation process. If the consumer wants to cancel, this is how you do it. Another piece of these legislative attempts that we've really tried to think through and that we worked with states. I keep saying we, I don't work at CFA anymore, obviously. So when I say we, I'm not talking about the New Jersey Attorney General. But at CFA, when I worked on these issues, we tried to think a lot about who was included and who was not in these bills and these statutes that eventually became law. We've seen a lot of exemptions in statutory click to cancel provisions that exempt whole industries, certain types of products, certain actors. There are some states that have cancellation laws that only apply to certain industries, like that might only apply to gyms, they might only apply to a certain other type of product. But the breadth and the scope of the law itself is a really important piece to think about as well. And not every, states are certainly not all on equal footing with that. Virginia passed a law this year on click to cancel. And I think part of what they did was really try to take out some of those exemptions, right? Put companies back into the law, make sure that the companies who are doing this are included in the law and have to play by the rules. And I think what that does for consumers is ensures that when you are a consumer and you have a subscription, it doesn't matter which industry is doing it. Your expectations are set that when you want to cancel a subscription, it will be as easy to cancel as it was to sign up. So it reduces confusion on the consumer end as well, that they know what to expect. We're all playing by the same rules. One type of company shouldn't get different treatment than another type of company. But that's another place where I think states have really tended to differ. So I hate using the phrase patchwork because I think it can often be a derogatory thing, even though I said it before. But frankly, I think it's going to happen at some point. And for larger businesses that operate in multiple states or even every state across the country, it would certainly seem to me that it would be easier to comply with one set of rules instead of 50 or 25 different states that have 25 different provisions. So the Federal Trade Commission rule, of course, would have done exactly that. It would have had a very clear standard for everyone because it was an industry-wide rule that leveled the playing field for everyone. But while states are picking up the mantle, I think, again, we've seen these clear through lines of like a simple cancellation mechanism. It might not necessarily be the same exact language in every state, right? Like some states might say, you have to let someone cancel online. Another state might say you have to let them cancel by sending a single email. You can't use a chat bot to require them to cancel. So there's different sort of like provisions and language. But again, I think the thrust of this is the same. We all identify with the problem, which is subscription traps and just difficult cancellation processes. So I think if we're all kind of trending in that direction, is overall positive movement, and it's something that really resonates with people and can help them in just like everyday issues that are annoying and problematic and can be very expensive, especially when it is by design, right? Like if it's designed to trap them and keep them in a product that they don't want, I think that's where it becomes really problematic.
Just to pick up on what you said, like states are not on like equal footing, right? Like I guess one way to look at it, like patchwork sounds like derogative, but like maybe you can say states are innovating, like you state is trying their approach, right? Maybe we see something work better than the other. But just to focus on one thing that you've talked about is that like the states approach things differently, but also I guess the potential tools or weapons they have, like do some laws would have more teeth to it, some do not so much. So what does a strong state click to cancel law would actually need to include? And like if something is considered weaker, what is falling short?
Well, again, I'm definitely not speaking on behalf of the Attorney General. This was my experience when I was at CFA, when we were advocating to individual states. But when I was there, we developed kind of like a model framework for states about what they should consider and how they should think about the provisions that they included in a click to cancel bill. So I touched on some of these before, but I think the regular reminders are really important. Telling people ahead of time that they're going to be billed. Cancellation that mirrors sign up. No exemptions, having an industry-wide bill or law that applies to everyone, that there aren't special carve-outs, no one gets special treatment because they happen to be in a particular industry, upfront terms and pricing about what the consumer is getting, and then accountability. This is something that I think really does, all of these kind of depend on the state, all of them depend on whether the state has had an existing auto renewal law or some particular industry provision that might be in like a totally different part of their code. But this accountability mechanism, I think, is extremely important because it in some ways solves a gap that would have been left by the Federal Trade Commission rule, even had it passed. So I talked about this before, but ensuring that it's privately enforceable, and that might be privately enforceable through that, just through that statute or just through that bill language that it says a consumer can enforce this on their own or whatever statutory language they might be able to use. That consumer can recover their attorney's fees for bringing the lawsuit and having to sue the company to get them to enforce the law and get what they deserve. statutory damages or penalties that ensure that the company is deterred from violating the law and that this isn't just the cost of doing business for them. Having meaningful accountability provisions in any law, I think, is a significantly important piece of it, because otherwise, violating the law just becomes the cost of doing business. If there's no incentive for the company to comply, if it doesn't become more expensive or difficult for them to comply with the law than it is to violate it, that can be a really easy decision for a company that doesn't care. Again, not everyone is in that boat, right? Like there are lots of companies that don't need this and they will do it anyway just because they're honest and they want to do right by people. They know they're providing a better product. They know they have a better price. And so they don't feel the need to like violate the law in order to run their business. But for the companies that don't care, or for whom complying with the law is a business or a financial decision, certainly we need those measures in place. And we need to ensure that there's meaningful accountability that not only individual consumers can take part in, but they might be able to band together in a class action if it is conduct that has violated every single customer of a particular company. That is absolutely a way to send a message to the company that this is not just the cost of doing business and they need to clean up their act. And then I guess another piece of this is like whether the statute or the law would be enforceable through the state's consumer protection statute, which is typically capable of enforcement by the Attorney General. And then they have all other sorts of tools that they can use to enforce that law through civil penalties, through injunctive relief, all the tools that AGs have that aren't necessarily available to individual consumers.
And zeroing in on New Jersey, how has New Jersey handled this issue? What sort of laws are on the books, or what has the Attorney General's office done?
So one of the things the Attorney General's office has done is joined a couple of lawsuits specifically about subscription trap cases. There's a multi-state case against a company called Uber. May have heard of them. It's Uber One with their subscription product. We joined that lawsuit as part of a multi-state alleging that Uber's cancellation process was quite difficult and violated lots of different state consumer protection statutes, but that it also violated the Retail Online Shoppers Confidence Act. This is a federal regulation that state AGs can enforce and talks about a lot of the same conduct. I think it only applies to internet sales. But the AG's office here in New Jersey has been very active on that, joining enforcement cases. I think we also brought a case prior to my time here against a retailer that had some very difficult cancellation processes in place, and we were able to resolve that matter as well. New Jersey does not have an industry-wide click-to-cancel bill on the books. I think we have some protections for consumers who have gym memberships, and those are on the books. But we do have a very expansive Consumer Fraud Act. That's our State Consumer Protection Act. And I was really excited to come to work in New Jersey and be able to use the Consumer Fraud Act because it's such a paragon of consumer protection. It includes very strong penalties. It includes strong relief. It's capable of private enforcement, which I feel strongly about. And it prohibits deceptive, unconscionable, and abusive conduct. So it's actually quite broad. And a lot of the conduct that we see that facilitates or worsens subscription traps very much could run afoul of our state Consumer Fraud Act. So I think New Jersey has really thought about this both in the enforcement context, but also through the Consumer Fraud Act and how that conduct does violate our existing laws.
Just to give us maybe one or two examples of the enforcement target or like what has been enforced upon, are these companies, I guess I would assume companies at this point, right, like would not just go out and flatly like just violate the rule or the law, but you don't know. So are these enforcement typically targeted direct companies just flatly ignoring the law or actually to be sneaky, right? Like technically complied, but designed somehow the cancellation flow to be really the maximally obstructive and annoying way that you cannot cancel?
Yeah, I think we've seen all different kinds, right? There are all different kinds of subscription trap enforcement actions that we've seen. But some of the trends that I've noticed with like the bigger companies that are operating nationally that rely a little bit more on tech are that these are probably processes that have developed over time and have just gotten more and more and more complicated and complex and difficult until they were sued. And so a really good example of this actually is the Federal Trade Commission's action against Amazon for its Prime subscription and the cancellation of that. The facts in that case, as the FTC alleged, were actually quite egregious and how difficult it was to cancel a Prime subscription. When you look at the complaint, you can see how the complaint alleges the way that the company was was like hiding buttons and using colors and just placement on the website as like these sneaky little tricks and traps that made it very hard to cancel. But it wasn't just that. It was like having to go through multiple click-through pages and confirming, clicking yes, no thanks, having to deal with the constant retention offers and like save offers, having to fend that off. And then once you kind of make it through that gauntlet, then you were given an opportunity to cancel. So it was actually very problematic, such that the Amazon famously referred to it as the Iliad flow in reference to the Odyssey, because it was just so complex and so difficult. So there are, I think, different kinds of subscription trap cases that are problematic. Another example on the non-tech side, I think, is the FTC's case against LA Fitness, where they alleged that if you wanted to cancel your gym membership, and I think this is the example that people think of when we think about subscriptions or difficult cancellation, is like a gym membership, because so many people have felt trapped in their gym memberships. I do think that in many instances that's kind of getting better as we're catching on to like what people want. But the FTC's case against LA Fitness alleges that you had to like fill out a specific form, you had to print it, you had to mail it to a certain address, and then you could only get the form, I think, from like one particular employee, and you had to go to their location to get it. It was like just very burdensome. That didn't even involve tech, but it did involve like having to go to a location, having to hope that the one employee who could process your cancellation or give you the right form was going to be there. And if they weren't, they couldn't help you. So there's all different kinds of ways that I think companies just kind of got used to this. They got used to like making it hard for people. And we've really had a sea change in how we think about it and creating this public narrative and really just a demand for better, right? People deserve better. If you're spending your money and you're choosing where you want to spend it, what company you want to give it to and what products you want, you deserve better customer service than that. And I think it's completely fair for us to expect better, frankly.
And with all of those obstacles that companies sometimes put in people's way, and because the digital subscription economy moves extremely fast, faster than legislative or regulatory cycles, how do you or other enforcers address these new modalities, such as in-app subscriptions controlled by the App Store, subscriptions bundled into hardware or AI as a service models, where the subscription might look more like a usage metered service? How do you address some of those?
Yeah, I think state AGs, like I said before, are stepping up in ways that are really heroic, that are extremely telling, and showing that AGs are taking consumer protection very seriously right now, because we know that we have to. One thing that I've seen a lot of state AGs offices do is really focus on accountability for tech companies. We have an entire section that focuses on data privacy and cybersecurity, and they do phenomenal work. They work very closely with our consumer fraud prosecution team, right? So we have a lot of different attorneys that are looking at these issues, different teams of people who are recognizing that there are all different sorts of like tech capabilities and things that can facilitate the violations of law. And I think state AGs, for their part, are recognizing that. They're staffing their offices in a way that accounts for this, right? To know that we are going to be taking on tech companies, that we're going to see violations of law that are just innovated, right? Companies are finding new ways to violate the law. And as AGs, we really need to keep up with that. And so I'm really proud to be in New Jersey, where I know that we're taking that very seriously. And I've seen many other states do the same thing. We've seen states make a real push to hire technologists, right? Like folks who can actually get in there, dig around and look at this much better than someone like me. I'm just a lawyer. I don't know too much about technology, but having the right people and the right tools and the right staff, that you can really build like a fulsome response to this and ensure that you are just as equipped to go after these companies as they are to defend the case that may be brought against them.
And again, a very unusual moment with the federal rule being dead and the FTC taking at least one step toward new rulemaking and states continuously trying to create their own laws. Do you think that many states will kind of use a wait to see approach about the federal rulemaking, or do you think that they'll continue to legislate in the interim?
I don't get the sense that states are waiting around for the federal government right now. I think states very much are seeing this as a moment where they need to be aggressive and step up. So I've not gotten that sense, at least not when I was at CFA and talking to other states about this. But I very much recognize that in New Jersey, we are not waiting for Washington to protect consumers. I think we're doing everything we can right now to lean in and find the opportunities and ensure that we're serving the public in a way that may not be happening at the federal level. So I think for New Jersey's part, we're not waiting for Washington. I think other states, whether or not they might be waiting for the federal government, I never really got that sense. I just think this issue is so compelling and so capable of successful legislation. And again, just helping people is a thing that touches so many individuals, and states across the country are seeing that. And I think really taking action, which is encouraging.
This has been wonderful. And maybe one last set of questions on this particular topic. In this general space, I guess we do call it subscription trap. Bear with us. We don't have a better term for now. What is the most underappreciated issue within this space for people who are actually practicing and maybe like observing, perhaps not that closely, but in a little bit distance, but not day to day? What would that issue be?
I think the most underappreciated issue is the impact on honest businesses. We tend to think about this as a very consumer-forward issue, and it is. And I think approaching this as a consumer protection problem is the way to think about it. It should inform our legislation, our enforcement, all that stuff. But when I was at CFA and we were thinking about allies and groups that might be able to support legislation, we really did try to partner with small businesses and local business owners who suffer competition at the hands of companies that steal competition through dishonest practices. And so I would say that for legislators that are thinking about this, I think there's some real allies there to be had that you may otherwise overlook. I think when we think consumer protection, we kind of get zeroed in on the same kind of groups or the same issues or the same thought processes, but thinking about the competitive disadvantage that is presented in our economy with subscription traps I think that's frankly kind of underappreciated.
Thank you so much. This is obviously a space that we need to continue to watch, and perhaps more discussions need to be had later on. Before we do that, and before we let you go, right, we're fortunate to have you on, and we want to seize this moment to give our audience the opportunity to learn about you as a person, as an individual, a little bit more. So perhaps you can tell us a little bit more, maybe just one thing about yourself that people who have only known you through your consumer protection work and like work you've done, they would not have known if they had only worked with you professionally.
I love a fun fact about people. So my fun fact that people might not know is that I'm from New Jersey. I grew up here and actually lived at home when I went to college and stayed and lived at home for another year after college. But the whole time that I was in college and the year after, I worked at a gas station for 5 years. And I worked at the convenience store and the gas station. And most of what I did was sell lottery, cigarettes, and hunting and fishing licenses in South Jersey. And I loved that job. It was wonderful.
That sounded fun. Thank you so much for joining us, Erin. This has been a great conversation. And Anna, thank you for being a wonderful co-host. And audience member, thank you for tuning in. Until next time.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.